Ricky Evans doesn't have an attorney.
Kind of a
mess.
That's
Yeah. Great. On the record in the matter of the people of the state of Michigan versus Ricky Evans. The file number is 23-00897. Council Pence.
on behalf of people.
Okay, and you're Mr. Ricky Vermont Evans? Okay, Mr. Evans, today was the date and the time. For a preliminary examination, my records reflect that you retained counsel by way of Dillon Law Group. Is that accurate? They filed an appearance, at least, or a substitution of counsel. They're not here today. You know why?
So your staff has received communication from Mr. Dillon that they haven't actually formally been retained, that no money has been collected. In fact, let me try to pull, Judge, let me pull the emails. So let me pull the email. It says, we were never retained on this file. We have not been able to collect any money for retainer. We did get a substitution of attorney signed, but we never submitted an appearance due to lack of payment, which as I can see, the court is holding up the appearance. Mr. Dillon is in Eaton County all morning and is not able to get onto Zoom for this hearing.
Okay, well, it sounds like we'll have to have our staff reach back out because not only do we have an appearance signed by Mr. Dillon on April 10th, there was a substitution of counsel. Mr. Austin signature was provided, and then it says that he gave permission, Mr. Evans gave permission to sign that. So I have that information noted here. So they need to appear. Otherwise, I'll have to show cost them and figure out why they're not appearing on something they appeared on. With that being said, we've already waived the 21 days. I'm going to have to reset this because I need to figure out what's going on with your attorney, okay?
I just also know our officer was here and he's actually still in the back waiting. I'm going to cut him loose here in a moment.
Okay, I'm just gonna go ahead and set it for a show cause. We'll set that for show cause. June 5th work for you?
Yes.
Well, really, I'm talking to him. He's going to
Yes,
court
Judge.
schedule.
Oh, yes, Judge. If it works for you, it will work for us.
At 9:15? At 9:15, we'll do a show cause hearing. And then we'll reset the preliminary examination after that hearing.
You said 9:15, correct?
9:15?
Mr. Evans need to be here, just so.
He does need to appear. We'll get you a notice to appear. Do you have any questions today, sir?
No.
Okay. Any additional matters for the record, counsel?
Nothing from the people.
Thank you. You're all set. We'll get you a notice to appear, okay? No problem. You said there was a waiver.
Mr. Green.
Mr. Green. Is he on this?
It's a 9:30.
On the record in the matter of the people of the state of Michigan versus James Anthony Hudson, file number 23-00765. Council appearance.
On behalf of the people.
Vince Green, on behalf of the defendant James Hudson, standing to my right.
Okay, Mr. Preston, today's the date and the time that was set for a preliminary examination. My understanding is that there's an unconditional waiver to circuit court, is that correct?
Yeah.
That was a great job.
Okay, was there an offer extended at all? Mr. Hudson, I do have a executed bind over form. Is there your signature on there?
Yes, ma'am.
Okay. Do you understand that you have the right to have a preliminary examination on this matter here in the district court? Understand that the purpose of the preliminary examination is to require the prosecution to meet their burden, which is to establish that they have a sufficient probable cause, that is probable cause that a crime was committed and probable cause to charge you with the crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive your examination? Okay, he's hesitated. Are you sure you want to waive your
Yes,
exam?
ma'am.
Okay, anybody threatening you to get you to waive your exam? Any promises being made to you in exchange for you waiving your examination?
No, ma'am.
And you're waiving it freely and voluntarily?
Yes, ma'am.
This matter will be bound over to the circuit court for June 7th. That's the date that the circuit court's gonna get the file from the district court. That's not a date you need to appear in court, okay?
Yes, ma'am.
Your next court date will be in circuit court. It will be a pre-trial date. Your attorney will be made aware of that. He'll be in contact with you, okay?
Yes, ma'am.
Can you confirm your address for me?
2524 Rio Road. Yeah.
Okay, very good. Bond will continue at 5,000 personal recognizance. Any additional matters for the record?
Nothing from the people.
Nothing else, Your Honor. He will be moving, but he's gonna notify me in the court of his no address.
Wonderful. You're all set, sir. Thank you.
Thank you, ma'am. Thank you.
Trying to think about the game. Really? Who's trying to do that to us? We need to find out. This is an assault.
Can't say.
I don't know. What do you want to do next?
On the misdemeanors? No,
Yeah.
she does not.
On the record in the matter of the people of the state of Michigan versus Donald Fleming, file number 22-01969, council appearance.
Yes, Your Honor, good morning. Assistant Public Defender Stephen Feigelson, attorney on behalf of Donald Fleming. Your Honor, was standing tonight.
How are you, Mr. Fleming? Pretty good. How are you, Mr. Feigelson?
Well, Your Honor, good to see you.
Same to you. Today is the date set for a sentencing. I do have a pre-sentence report. It was prepared on May 9, 2023. Did you get a copy of that report?
I did, Your Honor. I did a chance to go over with Mr. Fleming this morning.
Okay, is there reason to make any changes?
Just
updates or
one, Your
deletions?
Honor. He did go to Bear River in April of this year, but he finished in Bear River, I believe, yesterday, Your Honor, on the 23rd. of April. And he is now at Rise Recovery House here in Williamson, Your Honor.
And he's now at Rise, you said?
Yes, Your Honor.
Okay. No additional changes at this time?
None, Your Honor.
To make allocation?
Well, Your Honor, the report does ask for probation. I do believe that's appropriate here, Your Honor. Mr. Fleming has made a lot of positive changes in his life, Your Honor. He does have an addiction to substances and he's taking opiates, in fact, and he's taking the proper steps. He's gone to rehab and successfully completed rehab, and he's in the next step in his recovery that lies, Your Honor. It's a long process, but he believes he's going to do the things necessary to battle through his addiction to the substances, Your Honor. He does have an appointment with Mid-Michigan Recovery for further services on May 30th, so I do believe this is a man who will benefit from probation and will do the things necessary to get through probation successfully and work towards continuing his battle with substance abuse. And I look forward to seeing how that progresses. Thank you.
Did your client wish to make a statement at all?
Yes, Your Honor, I do would like to apologize for not coming up to court. And I apologize for my wrongdoing. I take full responsibility. I've changed. I've done completely 360 in my life. I went up the Bear River. I did very well there, completed it, and I'm in rise recovery. I got appointments for my primary care doctor down to MMRS. And I just hope that you don't have anything on me and go with the recommendation.
Thank you. I appreciate your candor with the court. You did this court, it looks like back in September of 2022, but you've been coming consistently, and since that time, it looks like you have made a decision to make meaningful change in your life. I do note here that even at the time of your assessment, you were preparing to enter into Bear River. You've completed that, and then now you're in Rise Recovery. So you're on the right track. You're doing the things that the court would have ordered you to do, or is going to order you to do, to address the substance abuse addiction, and hopefully continue to make strides in your personal life and wellness. Okay, sir? With that being stated, the recommendation was for a term of probation of 12 months. I think that is appropriate under the circumstances. I will adopt the recommendation. I'll sentence you to 12 months probation. While on probation, there's a $30 per month oversight fee that you would be responsible for. You're not to use, purchase, or possess alcohol, marijuana, or controlled substances unless you have a valid prescription, okay?
Yes.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're required to submit to random preliminary breath test and or urinalysis testing while you're on a term of probation. You're responsible for the fee associated with that, okay? Okay, you're not,
Judge, he is testing through Rise. I can have him get this. So
I'll note that here, he's testing through Rise. He won't be ordered to do additional testing. That could just be a release, that a release could be signed to provide that to probation, okay? Okay, also while on probation, you're not to be in any bars or nightclubs. Do you understand?
Yes, Your Honor.
I'm gonna order you to attend the 12-step meeting program to the extent that you're not doing that at or through Rise Recovery. I'm going to order that you continue your treatment and services through Rise Recovery. Let's see here. And you'll be required to obtain and maintain some employment once your health and state is at the position in which you could do so, okay? You have any questions so far about the probation terms?
No, Your Honor.
Okay, fines and costs, there's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that also has to be assessed for statute. I'm gonna waive discretionary fines and costs. Probation for 12 months will be $360 because it's a $30 per month oversight fee, plus the state minimum cost and the crime victim rights will bring you to a total of $485 You'll be advised through probation about making monthly payments on that, okay?
Yes, ma'am.
Do you have any questions about your fines and costs?
Will there be like some kind of leniency on that?
What do you say, what do you mean by leniency?
Like,
I'm not gonna put you in jail because you can't afford.
right,
your
like
fines
if
and
I
costs.
can't, like, this long as I'm making,
If you're doing everything else and you're not able to make the fines and costs because of your employment status, we're not putting you, I don't put people in jail for that.
Thank you.
Okay, so we'll address that. You can always be discharged from probation and that whatever's left of your fines and costs can be referred to collections. We can deal with that another way. The primary concern is to make sure you're doing your treatment
Yes,
and your drops, okay?
yes,
Okay, so you've signed this advice of rights as it relates to when and how you can request early discharge from probation. Do you have any question about these rights?
no, yeah.
Okay, counsel, any additional matters for the record
No, Your
today?
Honor, thank you.
Thank you. You're all set. Go up to you, sir. Advice of rights. On the record in the matter of the people of the state of Michigan versus Tiffany Janice Wiggins, file number 23-00022 FY. Counsel appearance.
Andrew Stevens on behalf of people.
And please support David B. Carter on behalf of Ms. Wiggins.
How are you, Ms. Wiggins? Good. How are you? You're doing well. How are you, Mr. Carter?
Good, thank you.
Okay, today's the date and the time that was set for a preliminary examination. My understanding there's been no contest plea.
That's correct, Your Honor.
That is correct.
Okay, what is the offer?
Your Honor, Ms. Wiggins will be tendering a no contest plea to an added count 2, child abuse in the 4th degree. That's MCL 750-136-5. Misdemeanor, punishable by up to 1 year of probation for up to 5 years. Unsuccessful plea and sentence to that count, if people move to dismiss count 1.
What is the purpose of the no contest plea?
Civil liability.
My understanding was, speaking with Mr. Carter, there's a sentence agreement between the parties pursuant to the court rule. Ms. Wiggins served no upfront jail.
Deliverable of no upfront jail. Okay, Mr. Wiggins, you heard the offer that was stated on the record by the prosecutor. Is that an offer you want to accept today? Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Yes. Okay, you can put your hand down. Have an advice of rights and plea information sheet with today's date on it. That's your handwriting? Yes, sir. Very nice handwriting, by the way. And that's your signature? Yes, sir. Okay, you read this document? Yes, sir. You understand all the rights listed there? Yes, sir. Do you have any questions about any of these rights? You understand that in order to accept this offer, you have to give up each of these rights? Yes, sir. So that means you're giving up your right to a trial, and you have the right to a jury trial. You recognize that? Yes, sir. And you have the right to the presumption of innocence. So as you stand here today, you're innocent until the prosecution can prove you guilty. So you have the right to have them prove you guilty by proving each element of the charge being brought against you. You have to prove each element beyond a reasonable doubt at a trial. You understand that? Yes, sir. And you're willing to waive that right? You're willing to waive the right to cross-examine, confront, or question any other witnesses that the prosecution intends to call against you. You're willing to waive your right to call your own witnesses or present evidence that you believe would further a defense to the charge. You're willing to waive your right to remain silent at trial and not have silence be used against you. Anybody threatening you to make you want to waive your rights today and plead guilty to the added count 2 of child abuse 4th degree?
No.
Any promises being made to you in exchange for a guilty plea? Are you currently on probation or parole? You understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to put a conviction on your future job applications.
Yes.
You also understand that a guilty plea can result in a conviction that may have some impact on immigration or travel that you may be seeking. So you may want to go on vacation to Canada, and this could impact that.
Yes.
And you understand that, and you're willing to waive your rights, understanding that.
Yes.
All right, okay. And you're entering a no contest plea freely and voluntarily, correct? Okay, as to you add count 2 of child abuse 4th degree, how do you plead? I have a police report here. Case number 22519075599. The date of the report was August 12, 2022 at approximately 8:30 p.m. Officers responded to Spiro Hospital referencing child abuse complaint where the victim sustained injuries to her upper right leg. The incident allegedly occurred on July 24, 2022 and July 31st, 2022 at an unknown time. The victim, initials DM, told officers that she got her injuries or had injuries to her right leg because she lied to her mother and was hit by a hair dryer cord. Officers observed a C-shaped cut, not fresh, on the victim's right leg. The father of the victim said he picked the victim up from the custody of the defendant, Tiffany Wiggins, week on, week off, that the father noticed later that the victim had several marks on her right leg. The victim told her father that her mom, person identified as Tiffany Wiggins, hit her with a dryer cord in the leg because she was being bad and lying. And that Tiffany told Elijah, father of the victim, that she forgot to mention she did use a belt on the victim for misbehaving. But she later stated she may have only gently with a hand. The incident allegedly occurring at the area of 5922 South Waverly Road, apartment 6, which is located in the city of Lansing, Ingham County, state of Michigan. A forensic interview was performed on the victim, initials DM. Victim was healing from a shaped marks on her legs. The victim stated that she was lying to her mom, and her mom got really mad and he whooped her. It was with a hair dryer or thing you straighten your hair with. The victim was asked when this happened, and she stated a few weeks ago. The date of that forensic interview was August 19, 2022. Any additional factual basis at this time?
None.
Court is satisfied with the factual basis. I find the reason for your no contest plea due to cite civil liability to be appropriate and will accept the no contest plea and finding to be made freely, voluntarily, and intelligently. There is a killable agreement that is to no upfront jail. That's agreement between you and the prosecutor. I'm not a party to that agreement. Do you understand that? That means that if I decide that I will deviate from that, I will give you the opportunity at the time of your sentencing to withdraw your no contest plea, okay? This matter is set for sentencing. It's gonna be July 20th at 8:30 in the morning. When you leave here, you need to go down to the 5th floor to the probation department so that you can complete a pre-sentence interview questionnaire. They'll then schedule you for an interview after that, okay? And they'll prepare a report for me to review at the time of your sentencing, okay? The sentencing can proceed via Zoom if all parties consent. You need to have video capabilities. You need to be in a position in which you are upright, stationary, and prepared to conduct an official court proceeding. Do you understand that? Yes. Okay. Do you have any questions for the court? No. Any additional matters for the record at this time?
Nothing from the people, thank you.
Nothing for the defense, thank you.
Thank you. You're all set.
Or do you retain the police report? Do you want me to take it
Oh,
back?
no, we can have that.
If you want it.
I don't want.
You could do either a plea on Armstead or a waiver on Fadley, or Fadley. It's one of the 10.
Martin. On the record, first in the matter, the people of the city of Lansing versus Leasia Renee Armistead, file number is 23-01169. Council appearance. You're not representing her on that matter, I don't believe.
I'm representing on the felony.
Oh, your attorney on that matter went outside, Mr. Lee. Okay, well, we're on the record in the matters of the people of the state of Michigan versus Leasia Armistead. In the other files, I have file number 22-01267, 22-03506, 21-02870. Council appearance.
Thank you, Your Honor. Aaron Hoskell on behalf of the people. However, I only am appearing in the felony matter, and I do believe that Ms. Wanji is only appearing on the felony matter as well.
Okay, well then, we need the other prosecutor on the other matters.
The plea, Your Honor, will only encompass the felony file, not the two misdemeanor files.
Okay, let's see. My records is that it has pending felony adjourned for global resolution. And so that's not what's good. That was why these misdemeanors were set for today. So that's not gonna happen.
That's not my understanding, and my apologies, Your Honor. Again, I only am visible on the felony drug file. I can see if there's a note that might.
Yeah, I wrote that note because that's what I was told.
My apologies, Your Honor. I may have to grab Mr. Stevens.
No worries, we can go off the record until we can figure this out and get Mr. Lee back in here. We can find out why Ms. Armistead can't keep up with all of the court dates.
Okay. Thank you, Your Honor.
So we're not having a PA 53 then? Is that what's going on? Hearing?
Well, we may with another prosecutor.
Got it.
We're not.
Yeah, we need to figure out what's going on.
My apologies, Your Honor.
No worries. Well, we don't have a prosecutor anymore. I don't believe. Are you a prosecutor, ma'am?
I'm a new prosecutor
Oh,
now.
okay, she's training.
Yes. Your Honor, Sage Castleman.
Hi, nice to meet you.
But I think Andrew is. Mr.
Andrew's
Stevens
on
is
the
on
hook for
the
today.
remaining files on the docket, Your Honor.
Sounds good.
I am on Mr. Timothy Hart, and
I'll wait.
Let me see what I can accomplish.
Ms. Armstead's not here.
She went down to go to that.
What are we doing next? A waiver?
We could do a waiver on Fadley and or we can handle Zachary Cowden. Not and or, just or. Can't do both at the same time.
Oh, they have a file for them. I don't have a file for them. Okay, we're on the record in the matter of the people of the state of Michigan versus Zachary Cowden. File number is 23-01265 FY. Council appearance.
Andrew Stevens on behalf of people.
Good afternoon, Your Honor. John Abbott representing Mr. Cowden. He's not here today. Good morning.
Well, it looks like I requested to have his bond revoked already this week because of violation of this GPS tether. You had communication with them?
No, Your Honor.
The court will issue. Will be remanded before court hearing.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing from the people, thank you.
Nothing for the defense. Thank you.
Thank you. On the record in the matter of the people of the state of Michigan versus Patrick Wilson, file number 23-00552. Council appearance.
Andrew Stevens on behalf of people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Patrick Wilson. He is not present.
Today was the date set for preliminary examination. My understanding is that Mr. Wilson was written to Clinton County and he'll be there until January 2024. So we need to send a writ to Clinton County to get him here.
Yes.
Looks like we've already addressed the timeline on this, so we will reset this and let him here.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing from the people.
Nothing from the defense.
June 29th at 1:30. June 29th at 1:30.
Yeah.
We're on the record in the matter of the people of the state of Michigan versus Leisure Armistead and the people of the city of Lansing versus Leisure Armistead. Council appearances.
Andrew Stevens on behalf of the people.
Madam Guilty One, Chair 24, Miss Asia Amsterdam.
Assistant Public Defender John Lee appearing on behalf of Asia Renee Armstead.
Okay, first taking the city of Lansing file, Ms. Armstead, you were supposed to be in court for furnishing false information on the 23rd at 9:30. You did not appear. Well, she's not the attorney on that.
Oh, no. I don't know about
What I can explain you, no, I think that there was some confusion on my client's part because when at last time she thought that all the cases were being put together and were going to be ended today.
I can see why she would be confused. It's got several different files, some dates in the same week, so I get it. We will reset that. You need to remember that this is a city file. So we don't have a city attorney here. You have to appear on the city day to address it. If I had not pulled a city attorney out of their office twice already this week, I'd have somebody come up, but I think they might be tired of me right now. But when I was down there, no one cared. They pulled me up anytime.
Shame on them.
But they no one cared. But it's okay. I'm not gonna do that. We'll reset this.
I apologize. Yeah.
You're fine. Was it put in JIS? I think did we hold it? Is that what happened?
It was not there.
Okay, so we never actually put the bench warrant in lien because we eventually.
It shows up in JS as a warrant status.
Does it?
Yeah, I just looked.
Oh, okay, sounds good.
I looked because I have a wrinkle to throw into some of this. I don't
I'll
think we need
quash
any
it.
more, but
And reset the city one. May 30th at 10:30. May 30th at 10:30. That's your date for the city case, okay? You can log in via Zoom so long as you're in an appropriate upright condition, prepared for an official court proceeding, okay? Okay, and then on the other matters, the state of Michigan versus Leasia Armistead, how are we proceeding?
Your Honor, in speaking with Ms. Wanji and Mr. Lee, and I know you were aware that Ms. Housefield from my office appeared on the FY file. I think it's my understanding in speaking with everybody and sort of representing my office on the two matters, what we're going to be requesting is that all of these matters be adjourned to a new date. The reason for that is while there was a plea agreement reached on the felony file, we have not reached an agreement on the two misdemeanor files. And while that may still happen, it seems sort of inconvenient at a minimum to have two misdemeanor sentencings and probation orders going at different times. Additionally, let me throw in another wrinkle that I sort of just uncovered and I haven't had a chance to convey to Ms. Wanji and Mr. Lee, is my office has authorized a new A&G warrant for Ms. Armstead that was signed 2 days ago. It is not yet in, I don't believe it's been sworn to, it's certainly not in JAS yet. So we have what would make a third misdemeanor case on top of the city that we have to address. So that further adds to the equation that it probably seems prudent to move all of this out so we can try to talk about everything globally. And I sort of, to Ms. Wanji and Mr. Lee, through you, Judge, I apologize for not catching the new case to talk to them in the hall because we've talked at length about this. I just caught it a moment ago.
Is that from the same incident as the PA-53?
Give me 1 second to compare the two.
Looks like this was an incident from May 7th. The PA-53.
This data, yes, it does appear that that is the case.
Okay.
Based on the complaint, it's charged with the date of offense of May 7th.
Oh, sounds good. Defense counsel, want to respond at all?
You know, I have discussed with my client, our case is almost resolved, so we don't have any problem with further adjournment.
Okay.
We're okay with the adjournment.
We'll adjourn for global resolution, and I You said your office authorized it this week?
5/23 of 23, it was signed. So it's my belief that it's on its way over to be sworn to and entered into JS. I would say probably within the week.
Sounds good. If I go on call next week, so I'm likely gonna get it.
Okay.
And so we'll make sure we get that taken care of, so then we can set it for a couple of weeks out.
June 5th.
June 5th
9:30.
at 9:30. Ms. Armstead, do you have any questions today?
Yeah.
What's your next two court dates?
When are they? The 30th and I forgot the last one. June 5th.
Correct, okay. Any additional matters for the record today, council?
Nothing.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Yeah. you can just approach and say, yeah. Oh, got it. That's not anything at all.
So,
Do you want to do this quick?
chill out. That Williams? What was it?
Basically.
Oh, okay. Oh, we didn't file that, that's right. We're on the record in the matter of the people of the state of Michigan versus Madeline Grace Fadley. File number is 23-00924. Council appearance.
I'm Sage Councilman on behalf of the people.
Good morning, Your Honor. Jared Austin, appearing on behalf of Ms. Fadley. She stands present to my right.
How are you, Ms. Fadley? I'm doing well, thank you. Today is the date and time that's set for a, preliminary examination. How are we proceeding, council?
There is a waiver in this matter. There is no agreement with that waiver.
Okay. Mr. Austin, that's accurate.
That is correct, Your Honor. That is my understanding. We will continue to pursue negotiations at the circuit court to bound over as charged.
Bailey, you understand that you have the right to have a preliminary examination here in the district court. You understand that the purpose of the preliminary examination is for you to require the prosecution to meet their burden of probable cause. So that is probable cause sufficient, that a crime was committed and sufficient probable cause to charge you with the crime. You understand that? You wish to unconditionally waive your right to that examination. So you understand that the unconditional means you can't come back later and decide you want to have your examination, and you're not waiving in exchange for anything, correct? Okay, anybody making any threats or promises to you to get you to waive your examination?
No.
You're waiving it freely and voluntarily. The bind over date's gonna be June 7th. That's the date that the circuit court will get this file from this court, okay? Your next court date will be in circuit court. It will be a pretrial. Both you and Mr. Austin will be made aware of that. You stay in contact with him, okay? You still have the address on Sadie Court? Okay. You need to keep the court abreast of any changes in your address. Bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
No, Your Honor.
Nothing further, Your Honor. Thank you.
Thank you. felony files for liaison, so we can pick two. It's always gonna be a plea, so we can do the same day, yeah. Set up for a plea on that day, that's fine. Get crowded, right? Or did I make that up? Did we do crowded? Okay. So we have Hart, we have William and Logan. That's it. Who's going first?
Logan,
Logan is first. We're on the record in the
Oh,
matter.
I'm sorry, strike that Hart.
Okay. Oh.
Hearts should be faster.
Quick.
Yes, that was right.
On the record in the matter of the people of the state of Michigan versus Timothy Franklin Hart, file number 23-00900FY. So Austin's not in here. Oh, council appearance.
Sage Castleman on behalf of the people.
And good morning, Your Honor. Jared Austin, appearing on behalf of Mr. Hart. He stands present to my right.
Thank you. Today was the date set for preliminary examination. Are we ready to proceed?
Yes, I believe so. Mr. Stevens is just grabbing the officer, which would be my first witness.
Okay, sounds good. Any preliminary matters?
I do plan on proceeding under the statutory courtroom MCL 768.27C that allows for statements regarding domestic violence to be admitted through the officer. I wanted to give the court notice of that. So that is my only preliminary matter.
Okay. Any other preliminary matters?
I was made aware of that, Your Honor. Beyond that, Your Honor, I have no preliminary matter, Your Honor. Thank you.
You can call your first witness.
All right, I call Officer Erica Halfman.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can take a seat, officer. State your first and last name, spell both of them.
Officer Erica Halfman, ERICKA, last name Halfman, HALFMANN.
You can proceed, counsel.
All right, Ms. Halfman, where do you work for? Lansing Police Department. All right, and were you on duty on March 19th, 2023? Yes, I was. What was your shift that day? At the time? Yeah. 6 to 4, 6 a.m. to 4 p.m. And on that date, were you dispatched to any type of domestic assault complaint? Yes, I was. Can you tell me about that? I was dispatched to an address on Jolly Road in reference to a domestic a male. The male was no longer on scene when I made contact. Male. And obtained a statement. And that Jolly Road address, is that in Needham County? Yes. And when you came in contact with the female, can you tell me about her demeanor? She was very upset about an incident that had occurred that day. Okay. And by upset, what are you talking about? She was crying and wanted to, I think, come forward with what happened. Okay. And in terms of the actual dispatch that sent you out to that location, was it the dispatch that sent you out to that location? Yes. All right, and what did that dispatch state? That she was assaulted by a male. Okay. And in terms of did you make any personal observations about the victim's appearance, such as any injuries? She did complain of shoulder pain. She had a little bit of redness to her left ear, a little bit of bruising. And then she complained of a few bumps on her head. I did not witness due to her hair. I couldn't see them. And then a bruise to her eye as well. Okay. And in terms of what she, I guess at this point, I'm going to ask if the officer may testify under MCL 768.27C, and since the call involved the domestic assault complaint, I can ask her more qualifying questions if you wish, but I do believe that there is evidence that her demeanor was such that an assault had recently happened, that this was under circumstances of truthfulness in terms of the police investigation, and that they were made to a law enforcement officer.
Any objection?
Your Honor, I think it laid the necessary foundation as far as the domestic relationship that is concerned. There are additional factors that the statute requires of the court. I would just reserve the right to either object or make additional argument about its conclusion of the testimony.
Right. Thank you. So in terms of, first of all, what was the victim? Did you apprise who the victim was? Yeah, Amara Door. Okay. And what did she state to you? She advised that her and Mr. Hart were in a dating relationship. That he was currently staying with her at her residence off and on. And that night we got into a verbal argument about a complaint of some infidelity. And she claims that he woke her up at 3 a.m. A verbal argument ensued. Mr. Hart pushed her down on the ground multiple times. It's then carried out into the hallway where she claims that Mr. Hart shoved her head through a drywall in the hallway and was kind of holding her head down by her hair after that and punching her repeatedly in the face. But she was able to get away by scratching Mr. Hart in his neck and face region. Before Mr. Hart left, she advised that he took her iPhone 12. Okay. And at what point did she call 911? She called 911 hours later. She advised that she went back to bed after he left, and when she woke up, she was in pain due to her injuries, and that's when she called. And she was in pain because of her injuries, and in terms of her demeanor at the time of making after, when she was making this actual statement to you, what was her demeanor like? Like I said, she was in pain due to her injuries and advised that she was going to end up going to the hospital. Said that they have prior domestic history that she had reported. They advised that she was
No,
scared.
I want to object to relevance.
You want to respond to the objection?
I do think that in regards to other domestic history, she's not going into specific incidences. She's merely explaining, it sounds like, why she was scared. I think her demeanor is important in terms of her feelings that she was expressing.
Is it being offered for the truth of the matter asserted?
It's not, however, it's not hearsay because I'm asking for it to be admitted through the statute. I believe that this is an other acts objection because she's about to go into other acts.
That's what your objection?
Yeah, my objection is, Your Honor, is that other acts are not germane for the purpose of bind over on these charges.
So I don't believe that I'm not asking for this testimony in regards to specific other acts. She was just talking in general as to why she is scared. I do think it's relevant. Can you tell us a little bit more about why she was, or her expressions of fear? She just said that Mr. Hart had a Sounds like substance abuse problem, maybe some untreated mental health issues, and that, because of that, they frequently, get into arguments, and she, like I said, she's been assaulted in the past.
So did she express any fear about calling 911 while he was there?
Not that I can recall.
Okay. And did she tell you about, when she went to bed, 'cause she went to sleep and then she got up and called 911, is that correct?
Yes.
Was Mr. Hart, was her boyfriend there when she went to sleep?
No, he had left.
Okay, and that is when he took the phone? Okay, and that phone, did she indicate who the phone belonged to? Did she give him any permission to take that phone?
No.
And as part of your investigation, have you ran a lien to determine who, or I guess, first of all, what kind of information did the victim give you about who this person was that assaulted her?
She provided us with the first, middle, and last name, an approximate date of birth, where he was residing in Waynesburg, I believe, and a phone number.
What was his, can you give me that information about his full name?
Timothy Franklin Hart, what she.
All right, and based on all that information, were you able to look him up in any type of law enforcement database?
Yes, we were able to look him up and lean and looking called the NLEX or an SOS photo.
Okay. And was he eventually, was he arrested that day based on that information?
Yes.
Right, and was that at the address that the victim provided?
I don't recall if that was the address that she provided or not. No, they located him at a house in Waynesburg.
So that was the city that she provided?
Yes.
Okay. And based on that photograph, do you recognize the person that was identified through lien in the courtroom today?
Yes.
Can you just tell me where he's sitting and what he's wearing?
So right here, wearing a white button up.
Okay, may the record reflect the lien identified defendant.
Any objections, identification?
Brief voir dire on that, if I may, Your Honor. Morning, officer. Did you ever speak to a Mr. Hart that day or later that day?
I did not.
Did you ever see anybody that day in person that you believe to be that person?
No, I did not.
Thank you, Your Honor. Your Honor, based on that, she never saw or spoke to, or was never able to confirm whether or not that was the person Ms. Jordan was speaking about. I would object to identification.
Could you respond to the objection?
I do think that the victim gave enough information in terms of, she only looked up the person on lien that's a verified law enforcement database. I can ask more questions to the officer about that if you would like me to.
You can just let this time.
What did you say?
You can ask more questions at this time.
Okay. So in terms of the database that you looked him up on, what is that called?
Law enforcement information.
Okay. And you had a number of different things you could use to look him up from the victim, is that correct?
So yes.
Let me see.
Yes.
And is that I guess, a record system that you typically use to find out who people are?
Yes.
And is that something you regularly use in your course of work as a law enforcement officer?
Yes.
Right. And have you found that law enforcement database to be reliable in terms of finding out who people are?
Yes.
Did you find any other Timothy Franklin Harts in that law enforcement database in this area?
Not that I can recall.
Okay. And did you find, in terms of the date of birth, was it close to what she gave you?
Yeah, I think it's a month off. I think she gave me a March birthday and it was actually February, if I'm remembering correctly.
Okay, but it was the same year?
Yes.
All right. And in terms of the photograph attached, was there any other Timothy Franklin Harts in the area that had other photographs or who were different people? Okay. What about in the city of Williamsburg? Is there any other Timothy Harts?
The way that system works, it doesn't show us
that. I just kind of, I'm not super familiar with how the search database works and how that populates. But nobody else came up besides. Okay. And did the victim give you any other information such as a different name or a different information that would contradict who Timothy Franklin Hart was? No. Okay. At this time, I'd ask if the record may reflect that the witness identified the defendant.
And just one follow-up question, you say you located a Secretary of State photo?
Yeah, it's called like an NLET Secretary of State photo, whatever's on their driver's license.
Okay, great. I found that there's probable cause sufficient to support identification, so identification is noted.
At this time, I don't have any further questions.
Cross-examination.
Thank you. Good morning again, officer. Well, when you spoke to Miss Dorr, this is the first time that you had spoken to her, interacted with her, is that correct?
Yes.
Okay. So as far as her demeanor goes, you have no prior experience with her to compare it to, is that correct?
Correct.
And you wouldn't be able to tell us whether her demeanor that day was either normal or out of character for her, is that correct?
Correct.
As far as your training goes in law enforcement, you don't have any specific medical training, is that correct?
Medical training, no, I just basic first aid.
But nothing beyond basic first aid. And you have no way of being able to determine any injuries that you observed on this door, precisely how long they would have been there, is that correct?
No.
Okay. And just based on your own observations or personal knowledge, you can't tell us who or what may have caused it, is that correct?
Correct. Just based off what she found.
And that's all you had to go by that day, just the statements that Mr. Dorr was giving you, is that correct? And likewise, you have no way of knowing the hole that you observed, how long that may have been there, is that correct?
Correct.
And you're unable to tell us from your own personal knowledge or observation who may have caused that, is that correct?
Correct.
And you wouldn't be able to tell us whether or not Ms. Dorr was under the influence of any type of alcohol or controlled substances that day, is that correct? And did she go into any precise detail about the phone other than just identifying it as an iPhone 12?
Just the iPhone 12, black in color with a white case that she provided.
And were you able to locate such a phone? Okay. And has Ms. Dorr given any indication to you that the phone could perhaps be tracked with some type of GPS or pinging it or anything like that?
I believe I asked her if we could look up on Find My iPhone, which said it's off. So I guess when it's off, you can't use that service.
Okay. And did you look into if there were any other measures that may have that you could have taken as a part of your investigation to see if you could have found it in some way?
I guess I'm not familiar with any other app that can track phones. That's the only one I'm familiar with is Find My iPhone.
Thank you. I believe that's all the questions I had.
Thank you. Any redirect?
No, thank you, Your Honor.
Thank you. May this witness be excused?
Yeah.
Thank you, Officer Haffman. Call your next witness.
I have no further witnesses, Your Honor.
Thank you. Is the defense calling any witnesses today?
We'll rely on the evidence presented, Your Honor. Thank you.
Thank you. You can proceed to argument.
At this time, I do believe that there's probable cause to bind over on the 2 counts, larceny from a person and domestic violence. That would be misdemeanor count, so we're only really here on larceny from a person. I do believe that there was all the elements established by probable cause to establish that the defendant did commit the offense of larceny from stealing the cell phone from Amira Door. And I do believe that the elements of MCL 768.2017 have been met in this matter, that this statement was made at or near the time of the infliction of a threat of physical injury or physical injury. She was still in pain when she woke up. When she woke up, the defendant was gone. It was made within 24 hours of the incident actually occurring. This was a domestic assault offense. And I do believe that the statement was made, of course, to a law enforcement officer. So I think that all the elements of the statute have been met. And at a probable cause basis, I think that we've met that at this point. So, Mr. Austin.
Thank you, Your Honor. Your Honor, I would be opposing the people's request for bind over. The only witness that we heard from today was the officer, someone who does not have any personal knowledge of what occurred. She's merely repeating what Ms. Dorr stated to her. The only issue before the court is whether or not there is probable cause on the only felony count in the complaint, which is the larceny charge. And outside of the statements of Ms. Dorr, there is no other evidence that would substantiate or corroborate or suggest in any way that that is a reliable or truthful statement other than those statements. There was no phone located. There was no attempts in any way to find such a phone. There was no evidence that Mr. Hart made any type of admissions or that such a phone was found on his person or in his home or anything like that. Given that, Your Honor, I would oppose the bind over and I would ask the court not find probable cause and dismiss it.
Thank you. Today's debate and the time that was set for preliminary examination. The purpose of the preliminary examination is to require the prosecution meet their burden, that is to establish that they have sufficient probable cause that a crime was committed and probable cause to charge you with that crime. So this is a burden of proof that's more than just mere suspicion that a crime was committed. This is not a trial, so this is not their time to prove each element beyond a reasonable doubt. That's a much larger burden. This is a relatively low burden of proof here. The evidence we have here is that by way of testimony of Officer Halfman, she testified that on the date of March 19, 2023, she was dispatched to the area or address on Jolly Road, located in the city of Lansing, Ingham County, state of Michigan, that dispatched dispatcher to that address in reference to a assault complaint. The defendant is charged in the complaint in count 1 of larceny from a person, count 2 being a domestic violence. The domestic violence as stated by the prosecutor is a misdemeanor, so we don't need to address probable cause on that. We only need to deal with the felony today and whether or not there's sufficient probable cause. Testimony was brought forth under MCL 768.27C in the absence of the alleged victim, Ms. Amara Dorr. The officer testified that she met with the alleged victim. The victim complained of assault by a male, that she stated that she was in pain. The officer noted redness to the left ear, bruising, and the victim complained of bumps in her head, which the officer stated she could not observe due to the victim's hair, and there was bruising to the victim's eye. The officer stated that the victim told her that she was assaulted by an individual by the name of Timothy Franklin Hart, that they had been in a dating relationship and that the defendant had been staying with her on and off, that a verbal argument had ensued over infidelity, and that the defendant woke the victim up at about 3 o'clock in the morning. The argument continued. The defendant pushed the victim down, allegedly shoved the victim's head into a drywall, punching the victim repeatedly in the head. The victim told the officer that she was able to get away by scratching the defendant, and that when the defendant left, the defendant took her cell phone, that the cell phone was taken without the permission of the victim. The victim reported pain due to her injuries and stated that she would go and seek medical attention. She reported prior domestic history with the defendant. As it relates to identification, she identified the defendant by first, middle, and last name gave an approximate date of birth. According to the officer, she believes that it was approximately 1 month off, but pretty close to date of birth. She gave his address and a telephone number, depending living in or resided in the area of Lanesburg, Michigan. Officer stated that they looked or searched the law enforcement information network, located a Secretary of State photo. There were no other Timothy Franklin Harris is located in Lanesburg. The defendant was, or the person that was identified as the defendant was arrested in the city of Lanesburg. The court would need to determine if there's sufficient probable cause as to count one, larceny from a person. Criminal jury instructions indicate that at the time of trial, the prosecution would then need to prove each element beyond a reasonable doubt. First, that the defendant took someone else's property. Second, that the defendant took the property without consent. Third, that the defendant moved the property, but it does not matter whether the defendant actually kept the property. Fourth, that the defendant took the property from, in this case, an Amarador person, or from her immediate presence. Immediate presence means that the property was physically connected to Ms. Dewar or was right next to her. Fifth, that at the time it was taken, the defendant intended to permanently deprive the owner of the property. Mr. Austin made arguments as to the lack of evidence as to whether or not there was a cell phone recovered, and other possible defenses or information that may create reasonable doubt, but this is not the time for reasonable doubt. This is the time for probable cause. The court did hear testimony by way of the officer that the cell phone was taken from the steward without her permission during the commission of an alleged domestic violence, and that it was that the defendant left the property with the phone. It doesn't sound like the phone was ever recovered, but the court does believe that based on the circumstantial evidence that the defendant intended to permanently deprive Ms. Dewar of that cell phone. The court is satisfied that there's sufficient probable cause as to count one, larceny from a person, that will be bound over to the circuit court. Count two of domestic violence will accompany. Your bind over date is going to be June 7th. That's the date the circuit court gets the file from this court. You do not need to appear in court on June 7th. Do you understand that, sir?
Yes.
Your next court date will be a pretrial. Both you and Mr. Austin will be made aware of that date. You stay in communication with him. Do you have any questions at this time? Bond was set at 15,000 cash surety with GPS tether and victim notification. Are we addressing bond for any reason at this time?
No, Your Honor.
No, Your Honor, I would just ask that it continue on its current terms.
Bond will continue. Any additional matters for the record?
No, Your Honor.
Nothing further on that, Mr. Hart. Thank you.
Thank you. You're all set.
She said that's the-
You doing Logan next?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Dorico Shaquan Logan. The file number is 23-00985 FY. Council appearance.
Andrew Stevens on behalf of the people. Good morning, Your Honor. May it please this court. Steve Cornish on behalf of the defendant in the court and standing to my right. Sir, would you please state and spell your name for the record?
Yeah, Dorico Shaquan Logan, D''RICO, Shaquan SHAQUON, Logan LOGAN.
Thank you. Today's the date and the time that's set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Any preliminary matters?
I do not, and in a moment I will go grab both the detective and my first witness, probably my first and only witness.
Thank you. And update from the defense.
As long as there's only one witness, I just normally request sequestration.
Sequestration will be granted if there's more than one witness. Thank you.
Your Honor, the people call Austin Young. Come on up, it's right up here, this seat right here.
Raise your right hand. Face me and raise your right hand. Stand, face me,
Oh, stand.
raise your right hand.
Sorry.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth on the penalty of perjury?
Yes, sir.
Thank you. You can be seated. So there's a microphone that's in front of you and the lady behind you is the court reporter. She has to take down everything being stated here today. So I need your responses to be verbal. They need to be loud and clear. So no head nods and shakes and mm-hs and uh-hs, because then we'll just have to ask you if that's a yes or no, okay?
Yes, ma'am.
And then if there's an objection from either side, you'll stop speaking. I'll make a ruling on the objection and then I'll tell you if you can give that answer or not, okay? Okay?
Oh, yes, Your Honor. All right, first time.
Are you okay?
Yes.
Okay. All right. And so I need you to state your first and last name and spell both of them.
Austin Young, AUSTIN YOUNG.
Okay, you can proceed, counsel.
Hey, Your Honor. Mr. Young, is it okay if I call you Austin?
Yes.
All right, Austin, do you know an individual by the name of Rico Logan?
Yes.
All right, do you see that individual in the courtroom today?
Yes.
Could you please point him out and describe an article of clothing that he's wearing for me, please?
That's him right there wearing a black collared shirt.
Your Honor, let the record reflect that Mr. Young has identified the defendant in this manner.
The objections ID.
No, Your Honor.
Identification is noted.
Austin, how do you know the defendant, Mr. Logan?
We worked together at Texas Roadhouse.
I'm sorry, I didn't mean to cut you off, sorry.
It's okay. We worked together at Texas Roadhouse on West Saginaw near Grand Lakes.
And about how long do you think you knew Mr. Logan? Or you have known Mr. Logan?
About 6 to 8 months.
Okay. Austin, I want to draw your attention back to March of 2023. Would this be a few months ago? Would this be within the time frame that you've known Mr. Logan?
Yes.
And more specifically on the date of March 24th of 2023, did you happen to be with Mr. Logan on that date?
Yes.
And do you recall where you were?
At his grandmother's residence.
Do you know the address of that residence?
I do not off the top of my head.
Okay. Do you know what street it was on?
No, I do not.
You know, where is it in the city of Lansing?
Yes.
Do you know, can you give us an idea as to where, or a landmark of businesses?
It was in the neighborhood. That's all I know. I was highly intoxicated when I arrived there. I'm sure the address. I don't know off the top of my head. No, I'm
Okay,
sorry.
that's fine. You said you were intoxicated. How did you get there?
I Ubered.
Okay. But you are certain that the house or the residence was in the city of Lansing?
Yes.
And would that mean it was also within Ingham County?
Yes.
And why is it that you went over to that address on March 24th, 2023?
I was planning on moving to Florida.
Okay.
And I just wanted to say goodbye to a few friends of mine before I left town. I was planning on leaving town 2 days after me and Rico had.
What brings you here today?
Yeah.
Okay. And so the stop at Mr. Logan's address was one of the say goodbye was the reason why you went over to see him.
Yes.
Right. You were intoxicated. Did you bring any alcohol with you that night?
Yes, I did. I brought Captain Morgan with me that night.
Okay. When you arrived, did you in fact make contact with Mr. Logan at that residence?
Yes.
Do you know if he had been drinking at all?
Yes.
And how do you know that?
There was a bottle of Patron that had been drank out.
Okay. Patron is tequila?
Yeah.
Do you know if based on what you saw, you know, if Mr. Logan was intoxicated, would you characterize him as intoxicated?
I wouldn't say visibly intoxicated, but I could tell there were signs of a little bit of inebriation.
And when you arrived, did the two of you drink together?
Yes,
So you at least at some point observed Mr. Logan consuming alcohol in front of you.
yes, sir.
Now, you said a moment ago that Mr. Logan resided with his grandmother.
Yes, sir.
Is there a specific part of the house that he stayed in, as far as you know?
The basement.
Okay, and is that where you, I guess I'll use the phrase, hung out with Mr. Logan on that date?
Yes, sir.
Can you describe for the judge, please, what happened in the basement on March 24th, 2023, please?
Well, I had asked Rico to come over to my house, but he insisted I came over to his. So I Ubered over to his house. He said the side door was open, so I went through the side door. Right as you go in, there's the basement stairs, so I went down to the basement. He was there. We had chit chatted for a while. Drank. I had already had.
The narrative. I think he needs to lead, not just.
Objection sustained.
You are now in the basement.
Yeah.
What are you doing in the basement?
Drinking and just chatting.
How long do you think that, if you can, how long did that go on for?
Roughly an hour.
Okay. What, was there an event that sort of stopped the chit chatting? Something happened?
I got tired because of how much I've been drinking, and there was a chair. I went over and sat in the chair and kind of just passed out for a little while. I woke back up. Rico seemed to be asleep on the bed. I couldn't sleep in the chair, so I laid on the side of the bed and pretty much passed out.
Okay. So the conversation between you and I think you've described Mr. Logan, you called Mr. Logan Rico.
Yes.
So the conversation between you and Rico ended largely because you fell asleep.
Yes.
And then you fell asleep on the chair and then moved to the bed.
Yeah.
And this is all within the basement room that Mr. Logan or Rico lived in?
Yes, sir.
Right. When you got on the bed, did you fall asleep on the bed?
Yes.
And where was Mr. Logan at that time?
He was on the far left. I was on the far right.
Of that same bed?
Yes.
And after falling asleep on the bed, do you recall if anything happened after that?
Yes.
Can you please explain to the judge what happened after that, please?
I woke up and my pants were below my genitals, and I could feel him on my genitals.
Okay. When you say him, are you referring to
I'm
Mr. Logan?
I'm referring to Rico, yes.
Okay. So you wake up and you feel or see or both?
Both.
Okay, so you feel it and you personally observed it.
Yes, I looked over and yes.
Okay. And when you say genitals, what part of your body are you referring to?
My testicles.
Okay, and what part, if you could see, what part of Mr. Logan's body was touching your body?
His mouth.
And what happened when you felt and observed that?
I immediately told him to stop, pushed him away, and got up off the bed.
Okay. You, and I want to make sure I'm clear on sort of the sequence of events.
Sure.
When you woke up, Mr. Logan was already touching your genitals with his mouth? Is that a yes?
Yes.
I see your head shaking.
Yes, I'm sorry.
Right. And so at one moment you're sleeping and the next moment you're awake and he is already performing that on your genitals.
Yes, when that started, it woke me up out of sleep.
Got it. Was it only your testicles?
To my knowledge.
That's
Yes.
all. That's all you.
That's what woke me up. That's all I recall.
All right, and that's what you saw.
Yes.
All right. And you told him to stop. What happened after that?
I got up off of the bed, pulled my pants back up. My pants I always kind of wear them sagging, so they just kind of down like that. I pulled them all the way back up. I started looking for my vape so I could leave. I couldn't find it. tell me when to stop if I'm going off topic here.
Go ahead.
I asked him for my vape. We started arguing about that so I could leave. I was just gonna walk home. I had no idea where I was. I was intoxicated. And we started arguing.
Okay.
I asked him to help me find my vape. He kept acting like he didn't know where it was. We started arguing back and forth.
And did there come a point where that argument became physical in any way?
Yes, when I turned around to try to just move, gave up on the vape, I was struck in the head with a bottle.
Okay. Was there anybody else in that basement room besides yourself and Mr. Logan at the time you were struck?
Well, his grandmother had come down after I think she heard a noise or she heard me scream or something, and I was laying on the ground.
Okay, but is that before or after you were struck?
That was after.
All right, so at the time you were struck, who was in that basement room?
Me, myself, and him.
Okay, so yourself, Mr. Young,
Yes.
and Mr. Logan.
Yes.
All right. What part of your body were you struck on or at?
This part of my head right here.
All right, and just so the record, you are demonstrating with your left hand, so the back left part of your head, is
The
that
back
accurate?
Left part and this side of my head right
All
here.
right, so right now, hold on, right now you are using your left hand to sort of about an inch or two above your left ear.
Yes.
Is that accurate?
Yes.
And do you know what you were struck with?
I'm not sure what type of liquor bottle it was. I know it was a glass liquor bottle.
Okay, and how do you know that?
I saw him grab it.
And then did you see him strike you, or did that happen when you were turned away?
It happened when I was turned away.
Did you see Mr. Logan with the bottle after you were struck?
No, I was knocked unconscious, and when I woke up, there was blood everywhere, and I got up and I sat on top of the bed, and my head felt really warm. I was very confused. I didn't even really know what happened. And then next thing I know is his grandmother I heard footsteps upstairs. She was irate and she came running down the stairs.
I want to back up a couple things. When you wake up and Mr. Logan is putting his mouth to your genitals and you tell him to stop, does he say anything to you?
No,
The-
not that I can recall.
Okay.
I believe he just stopped.
Okay. And you said stop and you moved away from him?
Yes, I immediately got off of it.
And then from that point is when you were trying to collect your vape, your personal items and get out of there.
Yes,
And then the argument, any exchange of words was relative to your personal items, not regarding what you had woken up to.
yes, it started with what he was doing. And then I wanted to leave, and then we started arguing over where my vape pen was.
Did you seek any medical attention for being struck?
They wanted me to go to the ER.
When you say they, who's they?
EMT, his grandmother called the EMT,
Okay,
and they showed up and they wanted me to go to the ER.
Okay.
But I refused, and an officer drove me home. And he got me up into my apartment, and I did not go to the hospital the next day because when I woke up, my whole bed was covered in blood from my head. So I realized that it was not going to stop bleeding, and I needed medical attention at that point.
I'm sorry, you say you did not go to the hospital the next day?
When they showed up on the scene, I refused to get in the ambulance and go to the hospital.
Correct, but you said the next day, you said you would not go, you did not go to the hospital the next
The
day?
next day when I woke up, I called 911 myself. and
Oh,
went to the
okay.
hospital.
Have you had any lasting effects from being struck?
Yes, I have a concussion. I've suffered memory issues. When whatever way I fell when he hit me, I landed on my left index finger. It's broken. I have 3 screws in it, keeping the bone together now. Um, That's it. It's concussion. Failure.
Okay, no further questions.
I just want to clarify the portion of where, yeah, you were struck from behind. You said it hit the left side of your head.
It hit right here. I was struck multiple times.
You said, and that was with the bottle. You said in the left side of your head, though.
Yeah,
The
right.
left mid. Okay, around the crown.
Yeah.
Okay, and did you ever see the bottle?
I saw a large glass bottle. I don't know the brand of it.
Okay, you saw that before or after you were struck?
After.
Okay.
I didn't realize it was there before it happened.
Okay, sounds good. Cross-examination.
Very briefly, Your Honor. Good afternoon.
Hello.
Do you remember what time it was when you went to my client's house?
About 2 in the morning, I believe.
And was that the first time you'd been to his place?
Yes.
You'd never stayed the night with him previously?
No, he has stayed the night at my house. I had a birthday party and I had a couple friends over, but it was always with other people in the mix, never just him and I.
Was your intent that night to stay the night at his place?
No, it was not. I was just highly inebriated and I just needed to sleep it off.
And you said you fell asleep in his chair, is that correct?
Yeah.
And then you got into bed with him?
Yeah, I fell asleep in the chair. Well, I tried to fall asleep in the chair, but I couldn't really go to sleep. And then I realized he was all the way over in the bed, so I figured it was a big enough bed where I could kind of sleep on the corner and sleep it off for a couple hours and then call myself an Uber back home.
And just because we're recording, when you say yeah, you mean yes?
Yes.
Thank you. This is the first time you'd shared a bed with him?
Yes.
And did you see him strike you with the object? You said it hit from behind. Did you see an object in his hand when you were struck?
Well, him and I were the only 2 in the basement, so I would assume that he was the one that struck me with an object.
I'm not asking who did. I'm asking, did you see him hit you with an object?
No, I did not see it. I felt it.
Okay. So you felt yourself get hit in the head?
Yes.
Multiple times?
Yes.
And then afterwards is when you saw the glass bottle?
Yes.
Was it broken or not broken?
I believe it was not broken.
To be clear, the 2 of you were not in any sort of dating relationship, is that correct?
Never, not whatsoever.
Anything else for you?
Let me redirect.
None, Your Honor.
May this witness be excused?
Without objection.
Thank you, Mr. Young. You may be excused.
If I may have just a moment to consult with Mr. Fleming.
Before he leaves?
No,
Oh, okay,
Yeah,
sounds
just in
good.
between, sorry.
Thank you.
You're good with that? Yeah. And if I could have just a quick.
No problem.
I'm ready. I could see that you were
I'm
working
just
on it.
responding to an email.
Thank you, Your Honor. At this point, the people are going to move to bind over, but there is going to be a request for an additional count or counts. So I'll start with just count one.
Okay, 1 second. I didn't ask if they were gonna call any witnesses.
Oh, sorry, my fault. I thought we did.
No, Your Honor.
Okay, thank you.
As for count one, is charged in count one, felonious assault and did assault Mr. Young with a dangerous weapon, to which a glass bottle. Based on the testimony from Mr. Young, people believe, at least for this stage, that crime has been satisfied. As the court knows, count two being an alternative count to count one and the misdemeanor, we don't have to deal with that at this point. Moving to the additional count. At this point, the people would be requesting a added count 3 of criminal sexual conduct in the 3rd degree. And I want to give the court both the code and the legal theory. For me, just 1 second. So it is 750520D. And it's under the theory that the act of penetration would be the oral stimulation of Mr. Young's testicles, otherwise known and referred to in the statute as fellatio. In the statute, specifically 750520A, paren R, describes sexual penetration as sexual intercourse, cunnilingus, or fellatio of any of a person's body or an object into the genital or anal opening of another person's body. And it is that basis that forms the act of penetration, specifically the oral stimulation of Mr. Young's genitals by the mouth of Mr. Logan. And it was done under a circumstance where the victim, Mr. Young, was physically helpless or mentally incapacitated at the time, specifically that he was sleeping at a moment in time and was roused from his sleep or slumber to Mr. Logan performing these acts on him. And so that would be the basis or the legal theory of an added count 3, criminal sexual conduct in the 3rd degree. Based on that, however, there could be an alternative count of criminal sexual conduct in the 4th degree, if, for instance, this court does not believe the oral stimulation of Mr. Young's testicles with the mouth of Mr. Logan to be sexual penetration, it would then equate to a sexual contact. And under the circumstances, that would be criminal sexual conduct in the 4th degree, which would be MCL 520 E1B, incapacitated victim. So the same argument or same facts as to the incapacitation, the fact that he was asleep when this started and woke up to that. And that would be an alternative count 4 to count 3. So I'm hoping to diagram that well enough. But based on all of that, based on the testimony of Mr. Logan, the people will move to bind over with the changes made at this point. I know those changes were sort of complex and require sort of a working through it. Does the court have any specific questions for me as to the counts that I'm requesting?
You're requesting to add count 3, CSC 3rd degree. You provided the theory of active penetration or oral stimulation, also known as fellatio, or in the alternative count 4 of a CSC 4th degree.
Right. Very good. Thank you, Judge.
Your Honor, it's a preliminary exam. I understand the burden of proof. I would leave it to the court's discretion today.
Thank you. Today was the date set for preliminary examination as stated by your counsel. The purpose of the examination is for the prosecution to meet their burden, which is a low burden, and that is a probable cause. So they only need to establish that they have sufficient probable cause that a crime is committed, probable cause to charge you with the crime or crimes. And this is not a trial. At the time of trial, the burden is on them to prove each element of each of the charges that they're bringing against you. Then they have to prove each element beyond a reasonable doubt to a much larger burden. But today, the burden is more than mere suspicion that a crime was committed. And that evidence is presented in the court today and measured by credibility of the witnesses. I am the sole determiner of the credibility of that witness. And the court can also determine the probability that the prosecutor will be able to establish guilt at the time of trial. Today, we had the testimony of one witness, that being a Austin Young. He testified that on the date of March 24, 2023, at a location that he could not exactly recall due to the level of his inebriation, but he was certain that it was in the city of Lansing, Ingham County, state of Michigan. He stated it was in a neighborhood of Lansing, to be exact, that he Ubered to the defendant's house on that date. He identified the defendant in the courtroom as Dorico Shaquan Logan. He said he had worked with the defendant at Texas Roadhouse, had known him for about 6 to 8 months, and that he had gone to the house to say goodbye or hang out before moving to Florida, that they had been drinking. He had been drinking before he got there, and that he brought a bottle of Captain Morgan. He suspected the defendant to have been also drinking based on, I guess he exhibited some signs of inebriation, to at least to the victim, and that there was a open bottle of Patron, also known as tequila, that the defendant stayed in the basement of this house, which was also occupied by the defendant's grandmother, or was the grandmother's residence. They had been drinking for about an hour. The victim stated that he got tired and he was sitting in a chair and passed out while in the chair. So he laid on, he woke up and he was uncomfortable. And he then went to the bed in which he stated that the defendant was already in and he assumed to be sleeping. And that he laid on the side of the bed with the defendant. He stated he was on the defendant was on the far left side of the bed. Victim said he laid on the far right side. He indicated that he woke up to his pants below his genitals, and that he said that he could see and feel the defendant's mouth on his genitals, specifically his testicles, that he immediately told the defendant to stop, pushed him away, pulled up his pants, and proceeded to look for a vape, which proceeded into an argument. Uh, He decided to abandon the search for the vape, and he stated as he was leaving, he was struck in the head. He described or positioned his hand, what the court perceived to be on the left side, upper near the crown area of his head. The victim stated that he was knocked unconscious, so he wasn't 100% sure what happened. He said he really don't know exactly what happened, but that he was still in the basement with the defendant at the time. And when he woke up, he saw blood on his head. There was some commotion, causing the defendant's grandmother to come downstairs and call 911. He said that he did, and this is when he was questioned by the court, see a large glass bottle after the assault, but he wasn't sure exactly what kind of bottle it was, whether it was alcohol or not, but that he did describe a large glass bottle that he presumed was what was used to strike him in the head. EMT was called. He refused EMT on that day, but stated that after he was brought home by law enforcement, he fell asleep and woke up with a sufficient amount of blood to cause him to go back or to call 911 the next day. He stated that he had or suffered a concussion, that he suffered memory loss, and that he, during the assault, landed on his left index finger, which he said was broken and required 3 screws. The people have charged the defendant with count 1 of assault with a dangerous weapon, also known as a felonious assault, and the alternative, assault and battery. Count 1 is a felony. To prove that at the time of trial, the people would need to prove beyond a reasonable doubt that first the defendant either attempted to commit a battery on the complainant, that being Mr. Young, Mr. Austin Young, or did an act that would cause the person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of a person or something closely connected with the person. Second, the people will need to prove that the defendant either intended either to injure Mr. Young or to make Mr. Young reasonably fear an immediate battery. Third, that at the time the defendant had the ability to commit a battery, appeared to have the ability or thought that he had the ability. Fourth, that the defendant committed the assault with a dangerous weapon. A dangerous weapon is any object that is used in a way that is likely to cause serious injury or death. The court heard testimony again from Mr. Young as to the first element, that he was hit in the back of the head, what he perceived to have been a glass bottle. He was in the space in the basement after arguing allegedly with Mr. Logan. They were the only 2 persons in that space, and he was hit from behind with what he's described to be a glass bottle. The court believes a glass bottle to be used in such a way that it could be a dangerous weapon if it's used in a way to cause serious injury and or death. The allegation is that there was a strike to the head, which would cause the court to believe that there was probable cause that it was used to cause a serious injury or death. There was some serious injury by way of a concussion. So the court is satisfied that there is sufficient probable cause as to count 1, which is assault with a dangerous weapon. So that will be bound over to the circuit court. The people are asking for an additional count of criminal sexual conduct in the 3rd degree, or in the alternative of criminal sexual conduct in the 4th degree. At the time of trial, the people would need to prove, if found over on the CSC 3rd degree, I'm looking at criminal jury instruction 20.12, criminal sexual conduct in the 3rd degree. It says the defendant engaged in a sexual act that involved section C, touching of Mr. Young's genitals with the defendant's mouth or tongue. The defendant Allegedly, per the testimony of Mr. Young, he woke up to the defendant's mouth on his genitals. So the court is satisfied that there's sufficient probable cause as to bind over, to add count three. I'm sorry, is it count three? Yes, add count three of criminal sexual conduct in the third degree under criminal jury instruction C with the theory of active penetration or oral stimulation, also known as fellatio. That will be bound over to the circuit court for further prosecution. Your bind over date, sir, is going to be June 7th. That's the date the circuit court will get the file from the district court. Your next court date, however, will not be that date. It will be a pretrial. Mr. Cornish will be made aware of that date. We'll be in contact with you about that, okay? Bond was set at 2,000 personal recognizance. There is a no contact order in place for the protection of Mr. Austin Young. You're not to be within 2,000 feet of wherever Mr. Young lives, works, or goes to school. That bond will continue. Let's see, and you're still at the address on West Willow.
Yes, Your Honor.
Okay. Any additional matters for the record?
Nothing from the people. Thank you.
No, Your Honor.
Thank you. You're all set.
Oh, really?
Yeah. Right. Oh, that'd be great.
One more.
Jared, did you sign that form to transfer that to?
Are we running Williams?
Yes. That's Mr. Pfeiffer's case.
Oh, it's Mr. Pfeiffer here.
Last I saw, he was on the record with Judge Ford. I can go see.
Okay, we'll see if he's here and if he's ready to.
We have a request, Mr. Allen, since for 8:30.
I was told he did not appear, so I issued a bench warrant.
Yeah.
Okay, thank you.
No problem.
Hello, Your Honor.
Greetings. You look like you are fresh off the record.
Off two records, yes.
Indeed, indeed. Well, make that three. We're on the record in the matters of the people of the state of Michigan versus Christopher Williams, file numbers 23-00235 and 23-00758. Council appearances.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
And good afternoon, Your Honor. Jared Austin, appearing on behalf of Mr. Williams. He's present, standing to my right.
Thank you. Today was the date set for a preliminary examination on both files. Council, how are we proceeding?
Your Honor, the people are unable to proceed today on either file. The victim is not here despite actually having good contact with our office and wanting to testify. I called her, she hasn't answered me back. The people are still prepared to proceed for each case with the relevant officers under 27C, that being Officer Rebecca Hare and Officer Marquise Washington. Officer Marquise Washington, I found out last night, is on family medical leave, and Officer Hare, I found out last night, is out of the state on vacation. As a result, we're unable to proceed today. People would ask the court to grant an adjournment in the matter. I will note this was already adjourned once at the prosecutor request because at that time, no subpoenas were done whatsoever. Well, subpoenas were done this time. The officer on vacation, the officer on family medical leave, never got them because they're not there at the office. It was until I emailed them earlier this week to make sure they received them that they informed me yesterday they are unable to be here.
Council.
Thank you, Your Honor. Your Honor, I would ask the court to dismiss the matters against Mr. Williams. As the people have noted, there have been multiple adjournments, at least one at the people's request. Understanding, of course, Your Honor, the people would have the option to reissue if that is their desire. But at this time, Your Honor, given the length of the delays, I would be remiss, I think, if I didn't advocate for dismissal on behalf of Mr. Williams. He is on a tether, and that's what I'm asking the court to do at this time. Thank you.
Motion to dismiss without prejudice is granted. As indicated by your attorney, the people do have the right to reissue the charge against you. If that is the case, you'll have to be rearranged and a new bond will be set, okay? Okay? I said the people have the right to reissue these charges against you because it's being dismissed without prejudice. You understand that?
So they can just bring the charges back up whenever.
They can bring the charges back up if they have the ability to do so, meaning they have the witnesses ready to proceed, okay?
Okay.
Okay, so they can reissue those charges. And if that happens, you would need to post a new bond. You have to be rearranged, okay?
I have to turn myself in again?
Well, that's what happens if you get a charge issued against you, yes.
So, for example, if the officers come back from vacation or something, then they just want to bring the charge back up, I have to go do it all.
They have the right to do that because within the statutory period and it's being dismissed without prejudice because the officers failed to appear today. Okay?
Oh, and will I be able to get this tether off?
You absolutely can get the tether off. Then you also want to wait about 72 hours to make sure we remove any no contact orders from the system before you go into any exclusion zones or anything like that, okay?
So I got to wait 3 days?
No, you can get that taken off now, okay? But you don't want to do anything like show up to the victim's house or anything like that. That exactly. Okay, you have any other questions?
I can get some scissors and cut off? Or do I
No, you have not unless you got,
No.
how much does that cost again?
A lot,
No.
and it's technically another felony.
Yeah, it is. Yeah, you don't cut it off. You gotta go to Ingham County where they put it on and have them take it off.
Okay.
It's a very expensive piece of equipment.
Okay.
Okay? Do you have any other questions?
No, Your Honor.
Okay, any additional matters for the record?
Not from the people, Your Honor.
Not on behalf of Mr. Williams, Your Honor. Thank you.
Okay, if you hang tight, we'll get you a copy of the Nolly, okay?
Okay.
That's the dismissal.
All right. And I got called to JSU people.
That's the people that put that on your ankle?
Yeah.
Well, yep.
Call them and make sure they're aware of the dismissal and you can bring a copy of the dismissal order with you so that they can have it.
Okay, cool.
Don't touch that. We'll let them do it for you.
Yeah.
no, give it back to him.
And let's see the single most ridiculous way to earn yourself $1.
It really is. Okay, they're objecting to this destruction of records under NCL 764.26A. For the record.